Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, for tonight, we're going to talk about something that we have been warning about for about 4 or 5 months now. The left is never ceasing on their attack on the Second Amendment, and a lot of the time, they'll do it federal, real big splash, real big fury, but sometimes they do it at a state level, and more often than not, the state level is where it's all going down. If you guys will recall previously, we covered Colorado. They put some new laws in, a lot of things that were kind of annoying. They were violations of the Second Amendment, but the big one was they banned preemption. Now, if you recall, just a primer, preemption basically says individual local and town ordinances cannot pass laws that supersede state law. That's in a tiny little nutshell. Well, now Florida's going after it, but they're going after a different way, and that's what we're going to talk about today. This is crucial, guys. Let me know what you think in the comments field below. Spread this one out because the Florida State Supreme Court is getting involved, and this one is one to watch because it's just like Colorado, but from a different direction. So, everything's linked in the description box below, and I want to hear from you, but let's dive in because this is where it's going, guys. This is the next step. Florida Supreme Court agrees to hear post-Parkland case about local gun regulations. This is from the 9th. Okay. Now, to set this up, the Florida Supreme Court will take up a closely watched case about a 2011 state law that threatens tough penalties if city and county officials approve gun-related regulations. Now, this is unique in Florida because in Florida, they can actually sue the individuals like politicians, sheriffs, any kind of officer if they infringe upon the Second Amendment through legislation, action, anything of that nature. And that's tied into the preemption law, and that's what they're trying to attack. So basically, they're fighting for the fact that they want state and local governments to set their own gun laws or their own gun right or avocation laws instead of the state level, right? If I can't get it up here, I'm going to try it down here. These guys are never ending. But that's what they're trying to do. Now, the court issued an order Thursday saying it will hear a challenge to the law, which was upheld in April by the First District Court of Appeal. A coalition of local governments and Agricultural Commissioner Nikki Fried, who's also running for governor, by the way, brought the case to the Supreme Court in June. This is a coalition of the most left-leaning states cities and towns in Florida. They're bringing it to the state court to fight the rest of Florida because this is a statewide law. Now, it's already been backed up by the First District Court of Appeal. And remember in Colorado, the way that they removed this was they repealed it through a voting process, which is the legislature, which is the way they have to do this. This is going through the lawsuit in the judicial system. This one has a lot less chance of passing, but we have to pay attention to it because this is important. Florida, since 1987, has barred cities and counties from passing regulations that are stricter than state firearms laws, and the penalties in the 2011 law were designed to strengthen that preemption. So the first time it was passed was in 87, then after that they reinvested energy into it in 2011 where they added the fines. Now that is the important part because they put teeth on it, and the left doesn't want that, okay? And here's a quote. The First District Court of Appeal ruling, also threatens fundamental principles of representative democracy enshrined in the Florida Constitution, the brief said. This is the plaintiff. Without these immunities, the risk of a subsequent adverse judicial determination of preemption will chill the ability of local governments and their respected officials to fashion laws they reasonably believe are both necessary to protect public health and safety and not preempted. Well, two things here. One, Florida is jumping on the public health and safety bandwagon. The left has figured out that if you just wrap everything in a public health safety thing, you have a better chance of doing it. That's the first thing they've done, even though they got shot down in the First District Appeals Court. The other thing that they've done here is they're really going towards the state should not supersede my laws in a local area. They're looking to model the Colorado ruling because they can't take the legislature in Florida the same way they did in Colorado, at least not yet. And Florida is getting more and more red as time goes on. This is what they're doing. They can't go this road, they're going to go this road. They're not going to go high, they're going to go low. They can't go low, they're going to go under it. That's what Nancy Pelosi said like 2 or 3 years, maybe like, I don't know, about 10 years ago. This is the point. They're relentless in their pursuits. But you and I, as Second Amendment advocates, we're on the cutting edge. And we're going to pass the Second Amendment blessings on to the next generation because it ensures the freedom that we enjoy. And that's the message I have for you tonight. Let me know what you think in the comments below, and I will see you on tomorrow morning's Bullet Points. This is Braden, signing out.